Hello, everybody. We have a document filed today in Colborn versus Netflix. It's a stipulation re proposed protective order. The other side is stipulate to entry of the proposed protective order provided here within Exhibit A. These parties request the court enter the proposed protective order to expedite the exchange of discovery between the parties in this action in the recognition that defendants Netflix Incorporated, Chrome Media, Synthesis Films, Laura Riccardi, and Maura Demos believe that discovery in this action will involve production of confidential, proprietary, and private information, documents, data, and other materials for which special protection from dissemination from use for any purpose other than prosecuting this litigation may be warranted. Defendants anticipate such information will include financial information, including the confidential terms of business contracts, as well as additional technical and commercially sensitive information and materials that could cause defendants competitive and other harm if publicly disseminated. These parties have requested a protective order in case, in good faith, they seek the order so that they might freely exchange sensitive information. This includes technical, financial, and commercial information from the parties themselves and third parties. The court thus finds that there is good cause to issue the requested protective order. Citations omitted. The proposed protective order is identical to the Eastern District of Wisconsin's model protective order dated August 19, 2021. And then they have the Exhibit A, which states proposed protective order based on stipulation of the parties and the factual representation set forth therein. The court finds that the exchange of sensitive information between or among the parties and or third parties other than accordance with the order may cause unnecessary damage and injury to the parties or to others. The court further finds that the terms of this order are fair and just, and that the good cause has been shown for entry of a protective order governing the confidentiality of documents produced in the discovery, answers to interrogators, answers to requests for admission, and disposition testimony. It is therefore ordered that pursuant Federal Civil P-26 and LR-26, designation of confidential or attorney eyes only information. Designation of information under the order must be made by placing, affixing a document or material in matter that they will not interface with legibility. The words confidential or attorney's eyes only. One who produces information, documents, or other material may designate them as confidential when the reason is good faith believes that they contain trade secrets or non-public, confidential, technical, commercial, financial, personal, or business information. 2. One who produces information, documents, or other material may designate them as attorney's eyes only when the person in good faith believes that they contain particularly sensitive trade secrets or other non-public, confidential, technical, commercial, financial, personal, or business information that requires protection beyond the afforded by the confidential designation. 3. Expect for information, documents, or other material produced in inspection of the parties' facilities. Designation of confidential information as confidential or as attorney's eyes only must be made prior to or contemporaneously with their production of disclosure. In the event the information, documents, or other materials are produced for inspection of the parties' facilities, such information, documents, or other materials may be produced for inspection before being marked confidential. Once specific information, documents, or other materials have been designated for copying, any information, documents, or other materials containing confidential information will then be marked confidential after copying, but before delivery to the party who inspected and designated them. There will be no waiver of confidentiality by the inspection of confidential information, documents, or other materials before they're copied, marked confidential pursuant to this procedure. Portions of depositions of party present, former officers, directors, employees, agents, experts, and representatives will be demanded confidential only if designated as such when the deposition is taken or within 30 days of the receipt of deposition transcript. If the party inadvertently produces information, documents, or other material containing confidential or attorney eyes only information without marking or labeling it as such, the information, documents, or material shall not lose its protective status, though such production and parties shall take all steps reasonably required to assure the continued confidentiality. If the producing party provides written notice to receive the party within 10 days of discovery of inadvertent production, identifying the information, document, or other material in question, and corrected confidential designation. Disclosure and use of confidential information, documents, or other material designated confidential or attorney's eyes only under this order must not be used or disclosed by the parties, counsel for parties, or any persons identified in subparagraphs and below any purpose whatsoever other than preparing for conducting the litigation in which the information, documents, or any other material were disclosed, including appeals. The parties must disclose information, documents, or other material designated as confidential. Putative class members not named as plaintiffs. In putative class litigation, until one or more classes have been certified, nothing in order prohibits receiving party, that is a government agency, from following its routine use of sharing such information, documents, or other material with the government agencies or self-regulatory organizations as allowed by law. 1. Confidential information. The parties and counsel for the parties must not disclose or permit the disclose of any information, documents, or other material designated as confidential by any other party or third party under this order, except the disclosure may be made in the following circumstances. A. Disclosure may be made to employees of counsel for the parties or when the party's government entity, employees of the government who have direct functional responsibility for the preparation and trial of the lawsuit, and such employee to whom counsel for the parties make a disclosure must be advised of and become subject to provisions of the order requiring that the information, documents, or materials be held in confidence. Disclosure may be made only to employees of a party required in good faith to provide assistance in the conduct of the litigation in which the information was disclosed or identified as such in writing as a counsel for other parties. In advance of the disclosure of confidential information, documents, or other material, disclosures may be made to court reporters engaged for depositions of those persons, if any, specifically engaged for limited purpose of making copies of documents or other material. Before disclosure to any such court reporter or person engaged in making copies, such reporter or person must agree to bound by the terms of this order. Disclosure may be made consultants, investigators, or experts, collectively experts employed by the parties or counsel for the parties to assist in preparation and trial of the lawsuit. Before disclosure to any expert, the expert must be informed of and agree to be subject to provisions in the order requiring the information, documents, other material be held in confidence. Excuse me. Disclosure may be made to deposition of trial witnesses in connection with their testimony in a lawsuit and court staff. Disclosure may be made to persons already in lawful and legitimate possession of such confidential information. Attorney's eyes only information. The parties and the counsel for parties must not disclose or permit the disclosure of any information, documents, or other material designated as attorney eyes only by any other party or third party under order to any other person in the entirety, except the disclosures may be made the following circumstances. Disclosure may be made to counsel and employees of counsel for parties who have direct functional responsibility for the preparation of trial of the lawsuit. Any such employee to whom counsel of the parties make a disclosure must be advised of and become subject to provisions in the order required that the information, documents, and other material be held in confidence. Disclosure may be made to the court reporters engaged for depositions, those persons, if any, specifically engaged for the limited purpose of making copies of documents or material. Before disclosure of such court reporter person engaged copies of the report, the person must agree to bound the terms of this order. Disclosure may be made to consultants, investigators, experts. It's basically the same thing, but maintenance of confidentiality, except as provided in the subparagraph B. Counsel for parties must keep all information, documents, and it's basically just same thing. trying to make sure that nothing gets out that they don't want us to see. To the extent of any answers, interrogatories, transcripts of depositions, responses to requested admission, or any other party papers filed or to be filed with the court, reveal or tend to reveal information claimed to be confidential. These papers or any portion thereof must be filed under seal by the filing party in the clerk of court, utilizing the procedures set forth. If the court filing contains information, documents, or other materials designated confidential or attorney's eyes only by the third party making the filing shall provide notice of the filing to the third party. Challenge of the confidential designation. A party may challenge the designation of confidentiality by motion. The movement must accompany such a motion with the statement required. The designated party bears the burden of proving that the information, documents, or other materials at issue are properly designated as confidential. The court may award the party prevailing any of such motion, actual attorney fees, costs attributable to the motion. Conclusion of litigation. At the conclusion of litigation, a party may request that all information, documents, or other material not filed with the court or received in the evidence designated as confidential or attorney's eyes only under order must be returned to the originating party if the parties so stipulate, destroyed unless otherwise provided by law. Notwithstanding the requirements of this paragraph, a party may retain complete set of all documents filed with the court, subject to all the restrictions of this order. So, they're probably not going to be able to see everything. So, yeah, but supposed to be getting that thing on the 28th this month about Stevens. I'm sure we're going to get a response back for this filing for Colborn's. Y'all have a good day.